Hi, I'm Adam Kerwin. I'm the founder of the Kerwin Law Firm, and this is the second video that I'm putting together. I wanted to start doing a series of these to explain various aspects of asset protection planning. And this is something that this topic of today is, I've written an article about. If you go to kerwinlawfirm.com, under the articles tab, you'll see it listed there. You can download it and read more about it yourself. But the topic itself is why the PA is the worst legal entity to house your medical practice. And which is kind of interesting. Most people find that counterintuitive, because the vast majority of physicians these days actually have their entity in a PA. And so I want to explain what the downsides are and what a better solution is. But before I get there, I wanted to just go over a couple things when we talk about using any kind of legal entity to shield yourself from liability. Why do physicians use legal entities at all? Unfortunately, a long time ago, the law decided, or certain judges decided, that professionals are special. Doctors, lawyers, architects, people that are considered to be professionals should not be able to use a legal entity like a corporation in order to shield themselves from liability or things that could go wrong. So take, for example, a home builder who sets up a corporation and builds a house for somebody. The house, family moves into the house, later the roof collapses, injuring or, God forbid, killing somebody in the home. The individuals who bought the house from a corporation can only sue that corporation, and the individual builder does not have personal liability, liability. Meaning that they can sue the corporation. If the corporation has any assets, they can take those. But the builder's assets, their personal assets, are off the table. You're not allowed to reach those because the corporation cuts that liability off. I think this is a rather ridiculous rule. The reasons espoused by the courts are that when you're dealing with manual services and products, that the law of contracts is enough. That you can contract, all the liability provisions can be held within a contract, but professionals instead should be held to the standard of care in their community, which really makes no sense. Maybe if you're dealing with comic books or comic book manufacturer or somebody who makes dish rags, there might be something to that. But as you can tell, people make heavy equipment that can injure individuals, children's toys, and the list goes on and on. Why should we professionals be held to a higher standard than people that make things that can really hurt us and our families? But that is what it is, and unfortunately I'm not able to change that. So let's just get down to what is a PA. The words PA, or the letters PA, stand for Professional Association, and a professional association is really nothing more than a corporation. A corporation is, you probably know what that is. It's a legal entity. You form it with the Florida Secretary of State, for example. And then the PA part, the Professional Association, means that it is also governed not only under the chapter dealing with corporations, but also Chapter 621, which deals with corporations owned by professionals. The number one rule that restricts anything under Chapter 621, professional corporations, is that they can only be owned by professionals. So one that's set up to hold a medical practice, for example, can only be owned by physicians. And this rule is actually very strict. So if a physician wanted to take the stock in their PA and put it into their revocable trust, for example, a plain vanilla estate planning tool, in order to avoid probate, that transfer is null and void. It's not allowed. And even if you go and you fill out the stock certificates and you name it in your revocable trust, Under Chapter 621, they say that that transfer is null and void, and it's as though it never happened. So unfortunately, you can't put it into trust. You also can't put it in the name of a spouse. This brings up the next point, which is why do we care? Why would you want to hold the stock in your medical practice in anything other than your individual name? And it's interesting, as I've been doing asset protection since the early 90s, and it's interesting, in most of the 90s people really didn't care about asset protection. Around 2000, people became more concerned because of the cost of medical malpractice insurance, and quite frankly just the number of lawsuits were increasing and juries were giving out bigger judgments. If you are sued for medical malpractice, then who owns the stock in your practice is not really of grave concern. They'll still be able to sue you, the physician, and they'll also be able to sue your employer under a legal doctrine called respondeat superior, and meaning that they can always sue you, the doctor, sue the corporation, and they can take the assets of each. But liability is so much more than just medical malpractice liability, and we're seeing that more and more these days. It's interesting, when I was even dealing with doctors in year 2000, 2001, 2003, pretty much all the way into the real estate boom, that was really the only liability that most physicians were concerned about. Then when we got to we watched the real estate bubble burst, and unfortunately there were a lot of physicians who invested in real estate, and this was because they not only had the credit, but they also had the cash to be investors. And when the real estate market crashed, there was an awful lot of physicians, unfortunately, stuck in a very uncomfortable situation. They were upside down on their real estate. I'm sure this is no surprise to anybody watching this video. And now they had banks and other creditors coming after them for the deficiency, or the difference between what the property is worth and how much the loan from the bank was. But it's not only bank liability. I've seen physicians get in automobile accidents. I've seen them involved in disputes with other individuals that result in a lawsuit. So anytime anybody were to, could potentially sue a physician, the stock in their practice is potentially at risk. Now remember that a P.A. is a corporation, so I want to just back up for a minute and give you a distinction between what is a corporation versus, say, a limited liability company. With your corporation, if let's say, for example, that you and I were to start a business, and we're 50-50 owners, and we set up a corporation, so it's Johnny's Pizza Inc. And I end up getting a judgment against me. My creditor can come in, they can take my stock in our restaurant, and now you're in business with my creditor. So neither one of us is happy. There's nothing that keeps a creditor, in other words, from being able to go in there and levy on or take my stock in the company. I'm hurt, you're hurt, and it's not a good arrangement. An LLC, on the other hand, is different. Limited liability company is what I'm talking about. So if we had started Johnny's Pizza LLC, we would have, and we're again 50-50 owners. Again, if I'm sued, this time the creditor is not allowed to come in and take the stock in my LLC. They're not allowed to vote my interest in the LLC, and it's really not called stock, it's a membership interest, but I'm use that word just because it's easier to understand usually. They can't take my stock in my LLC. They cannot vote the LLC membership interest. They're not allowed to reach any of the assets inside of the LLC. So the only thing that they really are allowed to get is something called a charging order or a charging lien. And what this means is that if our pizza business ever is profitable and starts making distributions or dividends to the owners, that whatever would have been distributed to me instead goes to my creditor. So it's not perfect if I'm paid in the form of a salary, and I happen to be head of family. We have a statute here in Florida that allows me to protect all my wages from being garnished. But that law does not apply to any distributions or dividends. The fact that it's a corporation means that there is no charging order protection as there would be with an LLC. So at this point, many times people ask me, why is it that I really care? My medical practice really, isn't worth anything per se, and I oftentimes ask them, is that really true? It may not seem like it's worth anything, but it really is. First of all, take for example the fact that you have accounts receivable, and accounts receivable owned by the company. If a creditor came in and took the stock in your P.A., they would also be entitled to then vote it and reach all the assets inside of it, including the ability to collect the outstanding accounts receivable. Oftentimes there's medical equipment owned by the P.A., and even if the medical equipment is used or has been depreciated for tax purposes, people will often say, oh, it's worth nothing, just look at my tax return, it's been depreciated to zero. But that doesn't mean that the asset isn't worth anything. If it was worth nothing, you would have thrown it away. Of course it's worth something. And more importantly, the cost of having to replace that item. So if it's an x-ray machine, for example, if you had to go out into the market and replace it after it had been taken by a creditor, the cost of replacing it would be rather significant. And that's where you really have to focus. If I'm a creditor and I'm wanting to exact money from you, and I know that if I take the stock in your medical practice, that A, I'm going to get some money. I'm going to get the money in the bank accounts. I'm going to get accounts receivable. I can sell your medical equipment on the secondhand market for something, even if it's not a lot. But what position would that put you in? First of all, you'd have to go create a new legal entity, and you'd have to go form, hopefully not this time, a P.A. You'd form a LLC that would hopefully be owned in a trust. This is something that I regularly help people do that are in situations like this. But not only would you have to go through the hassle and time and expense of creating a new legal entity, think of all the things that actually means. First of all, your new entity would have a new tax ID number, and I'm sure that has gotten the attention of many of you watching this video. A new tax ID number means that you have to reapply for Medicare, Medicaid, you have to renegotiate all your managed care contracts. The cash flow coming into your business is going to be seriously impeded, and it's probably going to be anywhere from 6 to 8 months before you're truly up and running with new cash rolling in the door. And this is significant. This is, as you can probably imagine. And if the creditor knows that this is the result that you're going to have to deal with, that gives them significant leverage. Whereas if you didn't own the stock in your practice, and instead it was in a protected place where nobody could take it, all that leverage would be erased, and there'd be very little that the creditor could do, or they couldn't use this tactic to try and go after you. Think again too, if with a PA you simply can't do that. You can't transfer your stock to anywhere, not to your spouse, not to a trust, not to anywhere. And even if you think you have done that, because your stock certificates are filled out in a way that shows that it's owned by one of the somebody other than you, a physician, that transfer that you did was null and void. Also consider the fact that most physicians and medical practices are taxed as S corporations. So with an S corporation, the reason that this is done is there is a tax advantage. If you, let's say you have a physician that earns $500,000, typically they'll pay themselves a salary of somewhere in the $200,000 range, and the rest of it they'll take in the form of dividends. And because dividends are not subject to payroll taxes, they're able to save the 2.9% Medicare taxes. So if it's $300,000 being distributed, that's an extra $10,000 in saved taxes in their pockets. So there's a good reason for taking some of your income out in the form of S-Corp distributions or S-Corp dividends. Now, if you have your dividends are flowing into your hands, in fact, there's a medical group that I've worked with where the dividends are substantial, and due to political reasons, the company has remained a PA. Nobody's allowed to transfer their stock to protected places, and some of the physicians have had problems. And when dividends are now being distributed to them, there's no place that they can really hide them. There's no way to protect that cash flow, which really impedes their ability to negotiate anything with the bank or with creditors or anyone else who would be trying to take something from them. The other advantage is that under the Florida Wage Protection Statute, and I'm not going to get deep into this, but there's an exception. Generally, your wages are exempt from garnishments as long as you meet certain requirements. One of these requirements, though, is that you don't have a controlling interest in the company that employs you. So if you are a solo PA, so you own 100% of the stock in your company, you're a solo practitioner, that means that your wages are not exempt from creditors' claims. But if you didn't have a controlling interest, if we could put more than 50% of your business, usually something more like 99% of your business, in a trust, there are ways, which I won't get into right now, of structuring it where you can really bolster, you can have a very good argument that not only are the dividends protected, but now your wages are protected, and where your wages weren't before. So I hope you're beginning to see why it's important to be able to hold the ownership of your medical practice in something other than directly in your name. There's a lot of benefits to doing that. So a question many of you might be asking yourself now is, well, if PAs have all these downsides, and if there's so many reasons not to use them, why are they so prevalent? Why have they been used? Why do so many doctors have John Doe MD PA? And quite frankly, it's interesting. I think it's really habit. There's never been a requirement under Florida law that a physician use a PA. So it's a professional association. So then why? Well, if you look back at the history, it's interesting. Back as far as like the 1890s, physicians were beginning to want to practice together, but they were facing certain problems. First of all, there's something called the partnership problem. And if under the partnership laws, if two or more people get together and to conduct a business for profit, then they have formed a general partnership, whether they wanted to or not, or whether even they have knowledge that they've done this or not. So if me and Joe get together and start coming up with a product or a service and we're doing it together, we have a general partnership, and the consequences of that can be severe. Because let's say that Joe goes out and signs some contract or does something really stupid from a business standpoint, they can sue not only Joe, because I'm his partner in a general partnership, they can also sue me. And even though I had no knowledge of what Joe did and did not participate in it in any way, if they get a big judgment against Joe or our partnership, they can go after my assets individually. So this is a huge downside facing physicians. The other one is that there are tax benefits, one I talked about before with S corporations, of being able to conduct business in a legal entity. And there were also some other, I think, rather silly concerns, things that only lawyers could come up with. People asked whether or not a legal entity like a corporation that is not physically capable of passing, going to medical school or passing medical boards could even be engaged in the practice of medicine. I think that's a rather silly contention, but lawyers come up with a lot of strange things. But one thing that they really were concerned also about was fee splitting. They wanted to make sure that physicians only shared fees with other physicians. The fear is that if there were shareholders in a medical practice that were not physicians, that there would be pressures put upon the doctors to conduct their treatment that they give the treatment that they give their patients would be based more on increasing profits than doing what's actually in the patient's best interest. But given all the pressures, and it was probably the tax benefits that the physicians were missing out on that was the strongest impetus towards changing this. In 1957, the American Medical Association finally said, yes, physicians are allowed to use legal entities, and so they started doing so. P.A.s were with this restriction on only other doctors. There were some states that actually required this, that the physicians have to use P.A.s, and that helped with the fee splitting. If the only people that could own an interest in or own the stock in a corporation that was a medical practice were physicians, the fee splitting issue wasn't a concern. So, but people, mostly lawyers, being conservative, even though Florida didn't require a P.A., started using the P.A. because let's not push the envelope, let's do it safe, and at the time, that might have been good advice. But that's how they began to be used, and pretty much, even though there was never any law requiring it, it just became habit. And I think that's the main reason why P.A.s are primarily used. Despite all their downsides, and despite now clear, evidence that they really are one of the worst ways to house your legal entity, they're continued to be formed on a regular basis. I see it all the time, and I see it even by attorneys that practice, their primary practice is helping physicians. So it's an interesting trend, but a sad one. At this point you're probably saying, okay, then what should I do? And you're either in one or two situations. You're either thinking about what kind of medical practice you're going to form, because you have yet to set one up. That's probably not the majority of you. Or you're somebody sitting there with a PA, and you're saying, gosh, I already have a PA, what can I do about it? First, let me address what I think the preferred structure is and how you should do it, and then I'll go back and address what you can do if you already have a PA and you already have your managed care contracts and everything already set up, everything's already tied to your tax ID number. First, rather than using a corporation, it's good to use a limited liability company or an LLC. As I explained before, LLCs have charging order protection, and therefore if you do own an interest in your LLC and somebody sues you, they cannot take the LLC membership interest from you, and so they can't vote the LLC membership interest. The only thing they could get is dividends if they're ever made. But if you have control over the dividends, then hopefully that isn't as big an issue. But remember that it's an LLC. It is not a professional LLC. It's not an LLC that's governed under Chapter 621 of the Florida statutes. So being that it's just a straight vanilla LLC, you're able to transfer your interest into something that's safer from an asset protection standpoint. Now that we've talked about the LLC being preferred over the corporation, the next part of the structure that I like is that you have voting and non-voting stock. So the voting stock would be represented, so of all the shares of stock in the LLC, we have 0.1% is voting. So if I have 0.1%, that entitles me to, and it's two doctors, for example, let's just say that, they each own this little half of the 0.1%. They own very little as far as the overall ownership of the company. And the remaining 99.9%, which is non-voting, can be held in any numerous types of asset-protected pots. For example, the non-voting interest could be held by a spouse of a physician. A non-voting interest could be held in a trust for the benefit of the spouse, or it could be held in the spouse's trust. The benefit there is that if it's held in a trust and the spouse, God forbid, passes on, the assets the ownership in the practice can pass back to the physician in an asset-protected trust rather than just outright and free of trust. And the other thing that's nice is most times in medical practices, people are reluctant to allow a physician to hold stock that has voting control and other benefits in the hands of a spouse. The divorce is a significant problem, and getting the stock back from a spouse can be difficult. This can, however, be addressed in the operating agreement, which is the legal agreement that governs the LLC. So you can say that if the physician were to terminate service for whatever reason, that the stock owned not only by the physician, the 0.1%, but also the stock that's held by that physician's spouse, trust, family limited partnership, whatever their asset protection device happens to be, is also required to transfer the non-voting stock back as a part of that transaction. And better yet, you can even contain in an operating agreement that the manager or the people that control the LLC can make those transfers even if the other person is unwilling to cooperate. So this is something you can draft into it that makes it a far better arrangement. So let's say that we have that. We have, let's just make it 3 doctors. They each own their little teeny 0.1%. The rest of it, one doctor holds his non-voting stock in a trust. The other one has held it or given it to their spouse, which is they're being held in their revocable trust. And the third physician is just a single gentleman who is owns both of his voting and non-voting stock. Because just because you can transfer the non-voting stock doesn't mean that you have to. So now each one of them ends up getting sued by some creditor. The first two that don't own the stock in their PA are in a much better situation. A, the creditor cannot take their 0.1% because it's an LLC. The best they can get is charging order protection, which again doesn't entitle them to vote, doesn't entitle them to reach any of the medical practice assets, and the only thing it gives them the right to do is to receive distributions or dividends. But if you only own 0.1% out of a $100,000 distribution, that means the creditor gets $100. So it's an extremely small amount of money that the creditor ends up getting, given that a full $100,000 has been distributed. And so you can see the creditor is not even likely going to pursue the cost of getting a charging order, because they know the ownership interest is so small that any dividends that are distributed are likely to be de minimis and not worth going after. It doesn't make any economic sense. Even though the physician has been sued, they can still have full voting rights with respect to their the medical practice, and not only are their wages protected from garnishment, assuming that they're head of family, which most physicians tend to be, but also all of their dividends, all of the money that is being distributed to them is no longer being distributed to them. 99.9% of that distribution or dividend is now flowing into a trust, which is protected from the claims of the creditors of both the physician and the spouse. If it was and this is why I like using trusts, because if you think about it, if the physician put the stock in the hands of their spouse, for example, and now both the physician and the spouse end up getting sued. Maybe they both signed a mortgage, or the husband got into an accident in the wife's car. Now both of them are being sued. They could get a judgment against the two of them. Tenants by the entireties then doesn't help anymore, and they could reach the dividends But if it was in a special type of irrevocable trust, and that's going to be another video of mine, don't be afraid of irrevocable trusts. They can be a lot more flexible than you ever imagine. In fact, I have an article about this on my website, and I encourage you to sit down and read it, because irrevocable trusts are not nearly as scary as you think. There's actually a special type of irrevocable trust that you can be the trustee of. You can pull money out directly. It's sometimes called the Special Power of Appointment Trust. I'm calling it a Florida Asset Protection Trust, and it's based on an old trust power called the Power of Appointment. And again, that's on my website. You can look into that. But you can see now, P.A.s really made no sense. They are corporations with the least amount of asset protection. You're not allowed to transfer them into any protected place. They are give the banks and potential creditors significant leverage over you, because they know that if they take the interest in the practice, that starting a new practice is going to be painful, both from a time standpoint, from a cash flow standpoint, and from an actual dollar standpoint. And all of this can be avoided if you use this LLC drafted properly with voting and non-voting stock. So it's a significant improvement over the P.A. So I told you I would tell you now, what if you already have a P.A.? You know, you don't want to go through the hassle, like I just told you about, of starting a new LLC, because that's a new tax ID number, and everything has to change. There could be tax consequences. Well, thankfully, that's not the case. In Florida, we have something called corporate conversions. And under our corporate conversion statute, you can take a P.A., which is a corporation, and you file some things with the Florida Secretary of State, certificate of conversion, and there's some, I won't go into all the details, but you are able to convert a P.A. corporation into a regular LLC, and you keep the same tax ID number. The result of the conversion, or the consequence, the end result of the conversion, is that it's the same legal entity for tax purposes, same tax ID number. If it was an S-Corp before, it's an S-Corp afterwards. We have IRS rulings on this that show that this is exactly the case. You get to keep your tax ID number. I've done many of these, and I can tell you that if you, as long as the I's are dotted and the T's are crossed, it's an easy, relatively easy thing to do. The process of converting over is painless, and then once it's an LLC, we can draft the operating agreement to do the voting and non-voting stock. There's other things that we can put in there to increase the likelihood of your wages being exempt from creditors' claims, making sure that the charging order protection is the only remedy. And so with, again, very little pain, it's a very relatively quick procedure. We can take your existing P.A., convert it to an LLC, you get all the benefits of this new structure without having to go through setting up a new medical practice. Well, I hope that was educational. I hope you can now see why the P.A. is the worst legal entity to hold your medical practice. And like I said, I wrote an article on this. It's several pages long. In fact, I have a copy of it here right in front of me. I think it ended up being 13 pages long. It goes into a lot more detail, and feel free to download it and share it with anybody that you think it might benefit. Just remember, asset protection is important, and please protect what's important in your life. It's worth it.